So we will reconvene our hearing on C-75, and we will now move to Acumen Law Corporation. Our next witness, represented by Mr. Paul Doroshenko and Ms. Kyla Lee. Welcome. And the Canadian Civil Liberties Association, represented by Ms. Abby Deschman, who is the Director of Criminal Justice Programs. Welcome. I know this panel may have to catch a flight right after their panel, so I want to let you start as soon as possible, and I'll turn the floor over to Acumen Law.
Yes, good afternoon. Thank you very much for asking us to, or permitting us rather, I guess, to testify at this panel. My name is Paul Doroshenko. I'm a criminal defense lawyer in Vancouver. Kyla Lee is my colleague and is probably the busiest impaired driving lawyer in British Columbia and the head of the Canadian Impaired Driving Lawyers Association. There's three things that we are in a position to speak to today and that we'd like to give evidence about. And the first is with respect to the change in the onus for bail in circumstances of individuals who are charged with domestic assaults. The second is the change to the limitation period to lay a charge with respect to summary offenses from 6 months to 1 year. And the third is the thing that we've heard already is quite contentious, and that is with respect to police officers providing evidence by way of affidavits. This is a significant concern for us because when we look at it, as far as we're concerned, it appears that the police can basically put their whole case in by way of affidavit. You take a look at the thing that's been mentioned before already, routine police evidence, and there's a definition of that that's supposed to guide a judge and I guess guide prosecutors and defense lawyers with respect to making those applications of putting things in by way of affidavit. And if you look at what is actually listed in there as routine police evidence, it is the entirety of a police investigation, collection of evidence, observations of the police officers. That's what happens in most summary offense investigations. So if you're dealing with, for example, an impaired driving case, it's a routine police evidence for a police officer to pull somebody over and make an ASD demand. It's routine police evidence for a police officer to get a fail on an ASD roadside breath tester. It's routine police evidence to make observations about a person's, observations of evidence about a person's status, whether or not their speech is slurred. This is all routine police evidence. And my particular concern is that putting evidence in this way is going to lead to wrongful prosecutions, and particularly in cases where people are self-represented accused and they don't know about this whole procedure to try and make an application to court to oppose the Crown's application to rely on affidavit evidence. From a defense lawyer's perspective, obviously this is something that we're going to challenge, but I've been trying to, since I read this section, trying to think of a single case in my career, and this is 18 or 19 years, where a police officer has testified in a trial and I did not have questions for that police officer on the basis of their testimony. So I'm trying to think of a case where routine police evidence is going to arise in such a circumstance that it's not going to be contentious in any way or not going to build on the case in some manner or another that I want to use for the defense of my client. And really what it comes down to, here's one of the fundamental problems with it. We have to put our client's argument to the court. We have to put our version of events to the witnesses who are presented in court. So if the Crown shows up and they proceed by way of this affidavit only, how do we put our version of events to that person? And then how does the judge make a finding of fact? How do they assess credibility in circumstances where all you've got is an affidavit of a police officer? Well, there's two different ways you can go. As a judge, you can say, I'm just going to accept everything that police officers put in this affidavit, which I can tell you, I don't think that's going to happen. And the next thing is you're just going to say, well, okay, somebody else is testifying that something didn't happen that way. The police officer hasn't been here to testify. There's been no cross-examination or testing of that evidence. Ultimately, I'm just going to, accept the evidence that I've heard from the people who are giving evidence that contradicts what the police officer has in that affidavit. And this is something that we've already seen in British Columbia with respect to the immediate roadside prohibition scheme, and that's something that Ms. Lee deals with all the time. Do you want to go ahead?
Yes, in British Columbia, we've seen the erosion of cross-examination through our immediate roadside prohibition scheme, and I have personally dealt with cases in the British Columbia Supreme Court on 2 occasions where police testimony by affidavit through that mechanism has led to findings of a superior court where an officer has either been providing evidently false evidence or committed apparent perjury. Interestingly, the same officer in both cases. I've also had the opportunity to cross-examine officers outside the immediate roadside prohibition context on the affidavit evidence that they submitted in immediate roadside prohibition cases for charges that arise collateral to the immediate roadside prohibition, namely driving while prohibited cases. And in those cases, when confronted with things that would constitute evidently false and apparent perjury in the police evidence, the police witnesses have realized the error of their ways only through my cross-examination, and sweeping changes to police practice in filing this affidavit evidence have been made as a result of the cross-examination that occurred. But if you eliminate cross-examination, you eliminate the opportunity for police to learn what they are doing doesn't meet the standard of truthfulness that's required of them. And in our brief, and I appreciate this committee only got it this afternoon, and so probably many of you haven't had the opportunity.
Ms. Lee, can I just ask you to slow down a little bit? The interpreters
yes.
are having trouble.
I apologize.
Thank you.
Ms. Lee conducts these hearings over the phone. They're 30-minute hearings, and she has to speak very, very quickly, and she's become accustomed to basically making her argument very rapidly. Both of us have to do that.
In our brief, I included a quote from the Supreme Court of Canada's decision in Innisfil Township and Vespera Township about the importance of cross-examination. And it's on page 9 of our brief, but it refers to the fact that in the adversarial system founded on cross-examination and the right to meet the case being made against the litigant, civil or criminal, is the procedural substructure upon which the common law itself has been built. The court goes on to quote, saying that for 2 centuries past, the policy of the Anglo-American system of evidence has been to regard the necessity of testing by cross-examination as a vital feature of the law. And this has to remain a vital feature of our justice system. The mechanism that's been proposed in Bill C-75 to deal with the testimony of police through affidavit fails to even set up a system by which you can determine whether cross-examination is necessary. It identifies factors to be considered, but it puts no time limits on notice, whether that's going to come of the day of trial, the day before trial, responding to that notice, when applications for cross-examination are to be heard. Whose application is it? Is it the Crown's application to not have the officer testify, or the defense application to have the officer testify? None of that is made clear. At the very least, if the ability, the right of cross-examination in a criminal trial is going to take place, very clear guidelines need to be set out in the legislation for when that can be avoided so that defense lawyers know what is going on. The last point I'll make very briefly is with respect to the reversal of the onus in these bail hearings involving spousal assault. And I think this bill neglects the impact that that's going to have on families, not only in separating people from their children and the negative impact that will have on those familial relationships, but also neglects the impact that will have on the reporting of domestic abuse. And we've seen similar circumstances in incidents cited in the brief in the United States where the jailing of domestic offenders has led to underreporting because people are concerned about losing the primary source of income or the mother or father to their children as a result of jailing individuals. And the impact on families cannot be understated. And so both myself and my colleague welcome any questions this committee has.
Thank you very much. And let's go to the Canadian Civil Liberties Association.
Thank you very much for the opportunity to appear before you today. This is a lengthy bill, so in the interest of time, I will dispense with the intros to my organization and myself. We support the goals of Bill C-75 and applaud the government for taking steps to address many issues in the justice system that are crying out for reform. We particularly welcome the attention to the deluge of administration of justice offenses that are appearing before our criminal courts, to our bail system, which is overly risk-averse, detaining and releasing too many people on too many restrictive conditions, as well as racial discrimination in the jury system and deep unfairness of the mandatory victim surcharge. In our view, reform in many of these areas, as well as in others, is overdue. My submissions today will